Okay, welcome. We're going to do question 6 from 2005 February. It's a full trust essay, which is about as rare as finding a unicorn because they don't regularly test trust where it stands on its own. So finding a trust essay that's only trust is very difficult. It's only been done twice in the last 18 years, 3 times in the last 18 years, I believe. So we're going to do the one from February 2005. Okay, as always, if you have not read the fact pattern, before you hit pause, read the fact pattern 2 or 3 times, at least 2 or 3 times. I mean, in an exam, we're going to do the exact same thing. So the reason why these are good instructional videos is not only do you learn the substantive law, but you learn how to approach an essay and how to do it correctly. So the first thing you want to do is always go to the call of the question. Always go to the call of the question first. Why? You need to understand what the examiners are asking, what subject it is, and where to keep your focus. Okay, here. How should the court rule on the requests made by lender, Kate, Bill, and alma mater? Now, they don't give you a lot there, but at least we know we have to separate it by lender, Kate, Bill, and alma mater. So we have 4 calls to the question, and that's how we're going to separate everything. Simple as that. Okay. Now take it from the top. One of the things you're going to notice is the way the examiners write the essays, very segmented. You'll see what I mean when we go through these exercises if you haven't already noticed it. Okay. Notice that it starts off in 2003, the next paragraph in 2004, the final paragraph, or the following paragraph in 2005. One of the things you are going to notice is each paragraph in 2005, that goes to call 1 lender. The next paragraph goes to Kate, then Bill, then alma mater. So when you approach the essays on the exam, go to the call of the question first. Know what the examiners are asking you. Gives you a very good insight on what you're focusing on. Then you read the fact pattern 2 or 3 times carefully. You don't want to skim things. You don't want to rush. The more you read it carefully, the clearer it becomes. Okay, so let's take it from the top, and we're going to assume that you've already read it 2 or 3 times, and now we're going to analyze it by doing the critical breakdown. In 2003, Sam executed a valid testamentary trust, naming Tom as trustee. So the examiners are saying formation is not an issue. Don't waste your time with the creation of a trust and everything like that. You're not going to need to. The terms of the trust state. Now let's break each individual provision down. A. All net income is to be paid to Bill, Sam's nephews, for life. So that means the trustee must pay all the income from the trust to Bill for Bill's life. So Bill is an income beneficiary, and we don't know what's going to happen after Bill dies, but after Bill dies, the money's got to go somewhere. All we know is Bill's the income beneficiary, so a trustee's going to have a duty to act impartially towards the income beneficiary and the remainderment. Okay. B. Tom may invade principal for Bill in such amounts as Tom in his sole and absolute discretion determines. This means it's a discretionary trust. The trustee has the discretion on how to distribute. All the income must be paid to Bill. But in terms of the principal, that's the money, that's the income is being made off of. The trustee may invade the principal in his sole and absolute discretion. So this discretionary trust gives Tom, the trustee, he has to exercise his discretion in good faith and within the standards of reasonableness. Now, what is reasonable? What's in good faith? Judgment call. But use your best instincts. C. The trust terminates on Bill's death, and any remaining principal is distributed to alma mater university. So the express terms of the trust provide when the trust is to be terminated. So we know that so Bill's the income beneficiary. Alma mater is the remainderment, which means after all the money gets paid out to Bill and Bill dies, then it goes to alma mater. So those are the express terms, and the trustee must follow the express terms. D. The interests of the beneficiaries are inalienable and not subject to the claim of creditors. What does that mean? Believe it or not, that's the spendthrift provision. So this is a valid spendthrift provision because it prevents the beneficiaries from actually, Sam is the beneficiary. I guess the alma mater is also a beneficiary, so it prevents the beneficiaries from transferring their interests, and it also protects the assets of the trust from creditors. So when it says inalienable, that means it cannot be attached by a creditor, and that means a beneficiary cannot sell or transfer their interest. The money has to go to Bill, the money has to go to alma mater, and they can't transfer their interest until they get the money. So Bill gets the income and they can do whatever he wants with it, but until he gets it, he has no rights to transfer it. That's the voluntary transfer. Also, none of Bill's creditors can reach the trust assets, and that is the involuntary transfer. That's what that means. Now, in 2004, Sam died. One of the things I'm going to point out to you that I want you to notice is if you draw a line across, you'll notice how this essay becomes very, very simple in terms of what we're looking at. So, the first paragraph that starts in 2005 goes to the first call of the question, Len. The second paragraph goes to Kate. The third paragraph goes to Bill, and the final paragraph goes to alma mater. So if you notice how the examiners do that, they do that very, very frequently. So pay attention to it when you're doing the essays. I like to draw the lines across to show you how that actually is done. All right, so moving on. Let's take everything one step at a time. We'll go to lender first, and we'll see what goes on. But you'll notice how each paragraph relates to the separate issue. One paragraph's lender, one paragraph's Kate, one's Bill, one's alma mater. So let's take a look at lender. And we would discuss everything else as it falls into place. In 2005, lender obtained a judgment against Bill for an unpaid credit card bill that includes charges for tuition, groceries, and stereo equipment. Okay. Well, the question is, can lender actually get at the trust assets? Because that's what they're going to talk about. Lender now requests a court order directing Tom, the trustee, to pay all future installments of trust income to it rather than Bill until the judgment is satisfied. Well, how can lender get at the trust assets? Well, the only way lender is going to be able to get at the trust assets because we have a spendthrift provision. And the spendthrift provision is protection from creditors. But there are a special class of preferred creditors. Does lender fall into that special class? Well, those who have furnished necessities. Food, clothing, shelter. Groceries fall under food. So lender will be able to attach the trust assets to pay for the grocery bill. But not the stereo. The stereo is not a necessity. And the tuition, you can go either way on that, considering a necessity may or may not be. So this is something the examiners love to do. Most people don't catch it. There's a yes, a no, and a maybe. That's how they do it. Yes, no, maybe. So when they usually give you like a laundry list of certain things, some are going to be yes, some are going to be no, some are going to be maybe, or there's going to be a yes, no, maybe like there is here. So what's going on here with the spendthrift provision is because stereo is not an essential item, you're not going to be able to attach it for that. The lender will be able to seek reimbursement for the groceries because it is a necessity. So we talked about having a spendthrift provision, which is protection from the creditors. And so lender may not reach Bill's interest until a distribution is made, and only then may the lender attempt to collect directly from Bill. So let's just say income payment is made to Bill, and Bill was to deposit that in his bank account, then the lender would have to attach the bank account in order to get payment. But until that happens, if that even ever does happen, if Bill's not wise enough to put the money in a bank account, he'll probably just get cash out because he doesn't want to have to deal with creditors. He's trying to avoid them anyways. They can still be able to attach it because lender is a preferred creditor to get the groceries. Now, how the tuition, again, that's a maybe. Now, how are they probably going to get the money, or could they possibly get the money from the stereo? And another way to get it is when the amount is in excess of the beneficiary's need. So let's say that a payment is made, an income payment is made to Bill for, let's say, $10,000 per month. Well, you probably don't need $10,000 a month to live on, depending on what your station in life is. So if the amount is in excess of what's needed for Bill's education and support, then lender may be able to attach it
for the surplus and able to collect the money for the stereo equipment. So payment that the beneficiary receives in excess of the amount that is necessary for education and support, and that's the courts use the station and life test, they may be able to attach the excess or the surplus money may be applied to the claim of a creditor for stuff like stereo equipment and the tuition. So the lender could seek reimbursement for any surplus of income that is to be paid to Bill. So that's what's going on in lender. And by the way, one of the things the examiners do, you'll hear me say this all the time, you'll notice it as you keep going. The most important calls, when there's more than 2 calls to the question, the most important call is in the beginning. They're going to put the most important calls in the beginning, the least important calls at the end. So don't rush to finish an essay. Take your time and put your best foot forward, because you're going to spend about a half an hour right here. 10 minutes, or maybe 15 minutes, 10 minutes, 5 minutes. That's generally the way it goes. Now, it's not an absolute, but it happens, I would say, 95% of the time, where if there's more than 2 calls to the question, you can almost always tell which one is going to be the most important call. It's going to be in the beginning. So you're going to spend a lot of time at lender. We're going to talk about the spend-thrift provision. We're going to talk about the special class of preferred creditors. And we're going to talk about the amount that's in excess, the surplus of station and life. That all goes into lender, and you're going to need to break these things down. Obviously, this goes to preferred creditor. That goes to station and life. This one you can fit in anywhere. Okay, now let's go to the next paragraph where we talk about Kate. Bill is now delinquent in making child support. Well, we know child support, they fall under the preferred creditors. Even though you have a spend-thrift trust, if you owe child support, the courts, you're going to be able to attach the assets of the beneficiary, because the court's like, hey, we're not going to make the public pay for this. When you got money that's coming in, you're going to make your child support payments. You're the one who has to do it, and that's why there's preferred class of creditors. It's based on public policy. Bill is now delinquent in making child support payments to Kate, his former spouse. So for public policy reasons, the spend-thrift trust cannot be used to defeat claims of child support, spousal support, or unpaid taxes. So what that means is a creditor will be able to attach the assets of a spend-thrift trust if they're for child support, spousal support, or unpaid taxes. Kate now requests a court order directing the trustee to pay all future installments of trust income to her rather than to Bill until the arrears are eliminated. And guess what? She will get that because she's a preferred class of creditor. Child support payments are exempt from the restrictions of spend-thrift provision. So Kate can attach Bill's right to receive future payments under the terms of the trust. Okay, that's why they're preferred, they take priority. Okay, that was pretty simple with Kate. That didn't take long. You notice it took a lot longer to discuss lender than it did Kate. You're going to notice it kind of trickled down from that point on. Next paragraph that starts with Bill. So we just finished with Kate, the child support and preferred creditors. Now with Bill wants Tom to invade the trust principal so Bill can promote a newly formed rock band. Tom has refused. Don't forget, as we mentioned earlier, it says in section B, Tom may invade the principal for Bill in such amounts as Tom, in his sole and absolute discretion, determines. That means this is the part of the discretionary trust, which gives the trustee it says unfettered or absolute or uncontrolled, still must exercise that discretion in good faith. Now, the discretionary trust gives the trustee some flexibility in dealing with changed circumstances, and the settler kind of puts the trust in the trustee and how to determine how to divvy out the assets, and in certain situations, go ahead and do what's necessary to invade the principal to take care of Bill. But it says Tom has refused to give Bill the money to promote a newly formed rock band. Bill now requests a court order directing Tom to invade the principal. So the court's going to look at it. All right, this is a discretionary trust, which gives the trustee discretion in deciding whether to make distributions. So it provides flexibility to deal with changed circumstances that the settler could not foresee. So you have to ask yourself this. The spend-thrift trust was set up so Bill doesn't lavishly waste money. And now he wants to form a rock band, and he wants the trustee to invade the principal. So the trustee has to exercise that discretion in good faith and under sound judgment, and it seems that Tom, by refusing to do so, his refusal seems to be reasonable, and therefore the court should not interfere with Tom's decision because it's made within the standards of good faith and reasonableness, and this is probably not what the settler, Sam, intended when he set up the trust, was to give Bill money to form a rock band. Okay, and the final paragraph, which goes to the final issue. And you notice how quick this one went. So good faith, sound judgment. Almost nothing here, a lot of issues here. So again, I cannot stress this enough. You have to remain calm when you're taking the exam, especially when you're doing the essays. Spend your time where it's necessary. Don't rush to finish. Do the best that you can possibly do in the first 45 minutes and then wrap up in the last 15. Don't rush to get to the end. You're gonna start throwing in all kinds of stuff that doesn't matter, and you're gonna miss it here, and you've already shot yourself in the foot. So make sure you spend the time where it's necessary. That's why it's so important to read the fact pattern 2 or 3 times so that you understand, at least 3 times. I mean, come on, you can't do it less than 3 times because you have to understand what's going on. It takes me at least 3 times to read this thing to make sure I catch everything and fully process what the examiners are doing and what are they testing and where the issues are. Finally, last paragraph. Because of Tom's refusal to invade the trust principle and because alma mater is concerned over Bill's debt difficulties, they think that people are going to be able to attach the assets of the trust, which will invade the principal. Bill and alma mater, so now we have the consent of all beneficiaries. All beneficiaries agree. And they want to modify or terminate the trust. The reason this is a good essay is it really covers, it covers 2 of the 4 sections of trust. It doesn't cover the creation or the trustee's duty. Well, a little bit of a trustee's duties, but really not good in that. But it's a really good essay to do like kind of the weird issues in trust. Okay, so all the beneficiaries agree they wish to terminate the trust in order to divide the trust principal, but Tom has refused. So both Bill and alma mater now request a court order to terminate the trust. Well, what are the ways to terminate the trust? That is if the settler and all beneficiaries agree. Settler's dead. So it's because Sam's dead right now, the only other way to do it is by the express terms, and the express terms won't have it terminating after Bill dies because it was set up for the income for Bill's life, then the money would go to alma mater. So by the express terms, it terminates. So it's not going to terminate now by the express terms, and the trustee also isn't given the power to do so. So the only other way to do it is if all the beneficiaries agree. Well, okay, great. We have all the beneficiaries agree. Problem solved? No. The reason is because the court will not terminate a spendthrift trust even if all beneficiaries agree because a material purpose remains. This is part of the Claflin Doctrine. Claflin, C-L-A-F-I-N, however you want to spell it. I'm doing it again. F-L-I-N. It doesn't matter. Material purpose remains. I gotta learn how to say that right. Claflin Doctrine. Whoever wants, if you know how to pronounce that someday, come up to me and say how you pronounce that. From 1889 Massachusetts case. I do know that. So all the beneficiaries agree, but a material purpose remains. What's the material purpose? Preventing Bill and Bill's creditors from getting access to his money. That the whole point of the trust was to support Bill for his life. And if Bill was to get the money, what's he going to do? He's going to piss it away. He's going to form a new rock band. His creditors are going to attach the money. And guess what? Sam, who's his father, or I think Sam was his father, or his uncle, wanted to protect Bill from Bill's self. And Bill is now trying to invade it. So the court's not going to allow that because it's inconsistent with the settler's intent. And so because the settler intended to provide for Bill throughout his life. And so therefore, you're not going to be able to terminate it even though all the beneficiaries agree because the material purpose remains. So let's do a recap with lender. With lender, we have a spendthrift provision which prevents the creditors of Bill from reaching the assets of the trust. But we have a special class of preferred creditors. We talk about necessities. We talk about the grocery. Also, we have the stereo equipment and the tuition, which the creditor could, which lender is the creditor, could attach if it goes above his station in life. So any surplus or the amount that's any amount that is paid for the income that is more than is needed for his education and support, lender may be able to attach to pay off the stereo bill. As for Kate, she's in the preferred class of creditors. Child support payments, they're going to be able to break through a spendthrift trust because they're a preferred class of creditors and they're exempt from the provisions of the spendthrift trust. So that's a creditor that can reach the assets of the trust. As for Bill, wanting to form the rock band, the trustee Tom it's a discretionary trust, which gives Tom the discretion to exercise good faith and sound judgment in order to prevent Bill from wasting the money and from invading the principal, so Tom does not need to make the distribution. And finally, alma mater, that's when all the beneficiaries agree, and even though they all agree to terminate it, the court's still not going to do it because the material purpose remains to protect Bill from Bill's self for not having the money be able to support him through the rest of his life. And there you go. That's a wrap. That's 2005 February Question 6 Trust. Hopefully you understood that. It made sense.